Welcome to panel 3, Big Ideas in Reframing Consent and Victimhood. I'm Sarah Gottlieb. I'm a clinical legal fellow at the Innocence Project Clinic here at the University of Baltimore. And I'd like to introduce our wonderful panel. First, to my right is Professor Lisa Avalos. She's an associate professor at Louisiana State University Paul M. Hebert Law Center. Her teaching and research interests are in the areas of criminal law and procedure with an emphasis on sexual offenses and gender-based violence. Professor Avalos' articles have appeared or are forthcoming in the University of Illinois Law Review, Brooklyn Law Review, Nevada Law Journal, Michigan Journal of Gender and Law, and the Vanderbilt Journal of Transnational Law, and others. Online joining us today, we have Professor Joanne Sweeney, who is a professor of law and associate dean of academic affairs at the University of Louisville, Louis D. Brandeis School of Law, where she teaches lawyering skills, writing for practice, freedom of expression, and comparative human rights. And she will be on screen for her presentation. Professor Sweeney's current scholarly interests include freedom of expression, feminist jurisprudence, and comparative constitutional law. To Professor Avalos' right is Professor Julie Dalstrom, who is joining us from Boston University School of Law, where she joined the faculty in 2017 and directs the Immigrants' Rights and Human Trafficking Program, which she herself founded. Professor Dalstrom teaches in the areas of immigration, human trafficking, public interest, and gender-based violence. Her scholarship has appeared in numerous journals and law reviews, including the California Law Review, UC Irvine Law Review, and the UC Davis Law Review. And finally, last but not least, we have Professor Emily Stolzenberg, who is an assistant professor of law at the Charles Whitger School of Law at Villanova University, where she teaches advanced topics in family law, land use planning, and property. Her research focuses on conflicts between autonomy and obligation in the fields of family law and property, and her work has appeared or is forthcoming in the Boston College Law Review, BYU Law Review, and Maryland Law Review. So thank you to all of our panelists, and without further ado, Professor Avalos.
Thank you very much for that introduction, Sarah. I'm here to talk about innocence beyond a reasonable doubt, Supreme Court nominees, and sexual violence. And this article that I'm working on grapples with the question of whether we should allow people who have been credibly accused of sexual misconduct to be seated on the Supreme Court, and how should we handle such allegations when they arise during the vetting process. Despite the importance of these questions and Anita Hill's repeated observation that the Senate needs a process for addressing such allegations, lawmakers have failed to act. They failed to act after the events of 1991, and they still have not done so. So the article that I'm working on does three things. First, I use the Clarence Thomas and Brett Kavanaugh hearings to demonstrate why we need a process for handling sexual misconduct allegations against SCOTUS nominees. And then second, I use my background in sexual assault investigation best practices to describe the contours of what that process should be. And then finally, I make an argument for the standard that senators should use to evaluate sexual misconduct allegations, arguing that we should use what I term an innocence standard, that the nominee has the burden of proving beyond a reasonable doubt that he is innocent of sexual misconduct. So let me jump in and start off with why we need a process. I highlight a number of reasons in the paper why we need a process, but given my little 15-minute compact time, I want to focus on just one of those reasons for the purposes of the talk, and that is that partisan commitment to a particular nominee interferes with the search for truth and impedes the need, impedes a thorough investigation as well as the need for it. In both the Thomas and the Kavanaugh hearings, allegations of sexual misconduct surfaced after a Republican president had selected a nominee, and Republican members of the Senate Judiciary Committee were largely supportive of that choice. And it should be abundantly clear that in a heavily partisan environment, it can be difficult and even impossible for members of the party supporting the nomination to objectively consider new adverse information about the nominee and to withdraw their support as a result. During the Kavanaugh confirmation process, a number of Republicans made comments indicating that they considered the process of hearing from Kavanaugh's accuser to be a minor irritation that would not prevent them from confirming Kavanaugh quickly. Lindsey Graham stated, once a decision had been made to hear from Christine Blasey Ford, "I'll listen to the lady, but we're going to bring this to a close," clearly implying that listening to Ford would not change his vote. And there were a number of other Republicans who made similar comments. A highly partisan environment where a nominee has already been named is not the time to introduce a new process for vetting sexual misconduct allegations. Sexual harassment and sexual assault are complex topics to understand, and it is too easy for those with partisan motivations to ignore process concerns and to focus on getting the nominee confirmed at any cost. So we need to get a process in place before another politically charged nomination fight occurs. What should that process involve? I'll jump into that next. A robust process for addressing sexual misconduct allegations against Supreme Court nominees should include a number of components, all of which must be adopted and implemented, I would argue, on a completely bipartisan basis. I want to name a number of components that we need, and then I'll take some time to discuss just a couple of them in depth. So first, I think that we need a commitment to the principle that sexual misconduct is disqualifying. Second, I think we need a clear and transparent process that encourages everyone with relevant information to come forward. In other words, people need to know what the process is and where to take their information. Third, we need a mechanism for transmitting information to the Senate Judiciary Committee in a confidential way. Fourth, we need a commitment to a thorough and a properly resourced investigation of any allegations. And then finally, we need bipartisan training for all senators on the realistic dynamics of sexual assault. And I'm going to, as I mentioned, I talk about all those components in the paper. I'll focus on the last two thoughts here in the talk, starting with this notion that we need a commitment to a thoroughly and properly resourced investigation. One of the things that is really the most fascinating and also disturbing to me about both the Thomas and the Kavanaugh hearings is how thoroughly journalists demonstrated after the fact that the Senate Judiciary Committee had utterly failed to thoroughly vet each nominee. Journalists have taught us that when the Senate fails to take sexual misconduct allegations seriously in the nomination process, when they abdicate their responsibility for advice and consent, journalists are waiting in the wings, and they will take on this responsibility and they will share their results with the American people. I want to just give a few quick examples from each of the two hearings, starting with Clarence Thomas. After the Thomas hearings, there were two highly regarded journalists, Jane Mayer and Jill Abramson, who published a book in 1994 called Strange Justice, The Selling of Clarence Thomas. And they demonstrated in that book how deficient the Senate's investigation into Clarence Thomas was by undertaking a full investigation into his background themselves. They spoke to at least 12 people with information about Thomas's habits that provided context for and lent a lot of credibility to Anita Hill's allegations. All of these individuals provided evidence to the authors that Thomas's personal habits may have bled over into the workplace in the form of comments that created a hostile environment for Anita Hill. To give a couple of examples, at least 6 of Thomas's college and law school classmates recalled Thomas's interest in and discussion of pornography. And what stood out to several of them was how much he liked to talk about pornography, giving graphic and detailed descriptions of what he had seen. One former law school classmate of Thomas's described Thomas as one of the crudest people I have ever met. He was one of those people who can sound dignified in a courtroom, but get him with friends and he's crude, profane, scatological, and graphic. But the Senate Judiciary Committee and the Senate, by rushing through the vote and declining to conduct a thorough investigation, never spoke with any of the individuals who were identified by Mayer and Abramson after the fact. And so the Senate lacked the full context around Clarence Thomas around Anita Hill's testimony. To move now to the Brett Kavanaugh investigation and to give a couple examples there, you will recall that after Christine Ford and Brett Kavanaugh testified before the Senate Judiciary Committee on September 18th, 2018, the White House agreed to order an FBI probe into the sexual misconduct allegations after a bipartisan request to resolve that issue. But from the beginning, that probe was limited to what the committee thought was necessary to satisfy the 3 Republican senators who appeared to be undecided about supporting Kavanaugh. And those were Susan Collins, Lisa Murkowski, and Jeff Flake. So the probe was never intended to examine all the relevant evidence of sexual misconduct. Rather, it was limited to what was necessary to persuade that trio of senators only. once Brett Kavanaugh was confirmed, numerous journalists picked up where the FBI left off and have exposed the shortcomings in the FBI's work in vetting Kavanaugh's candidacy. We now know that the FBI ignored over 4,500 tips about Kavanaugh, but we also know that they did that because they were focused just on what Collins, Murkowski, and Flake needed to hear. So stepping into the gap after the fact, 4 female journalists ended up publishing 3 books afterwards and endeavored to complete the abbreviated FBI investigation. So first, the first book to hit the press was Robin Pograbin and Kate Kelly's book, The Education of Brett Kavanaugh, which came out in 2019. And then it was followed by what, in my opinion, are even stronger treatments by veteran journalists, Ruth Marcus, who wrote Supreme Ambition in 2019, and then Jackie Calmes, who wrote Dissent in 2021. And the evidence presented by all of these authors taken together is very rich and extensive. And just to give 3 quick highlights from their work. First, all 3 of the books provide evidence that casts doubt on Kavanaugh's statements during the hearings that he never drank to the point of blacking out, with numerous former classmates of Kavanaugh confirming that to these authors that they recall Kavanaugh drinking excessively in high school, in college, and in law school to the point of blacking out. And of course, that's important in the context of Ford's allegations, because if you black out, you could very well be committing sexual assault and not realize it. So that's the first example. And then second, Jackie Calmes identified numerous witnesses who could corroborate Christine Ford and Debbie Ramirez's allegations. In the case of Ford, she identified 6 people that Ford confided in before Kavanaugh's nomination happened. She also spoke with several people who lent credibility to Debbie Ramirez's allegation that while she was a student at Yale, she was forced to touch Kavanaugh's penis while she was intoxicated. And then perhaps most disturbingly, all 3 of the books present evidence that a former Yale classmate of Kavanaugh's, Max Steyer, witnessed a second incident involving Kavanaugh's penis and a second drunk woman who was made to touch it during college. I think that those who voted to confirm Thomas and Kavanaugh may have been operating under an assumption that once each man was confirmed and seated on the court, public opinion about misconduct allegations would disappear. But this is a faulty assumption to make. And senators should be aware going forward that if they fail to undertake a thorough investigation of sexual misconduct allegations against a SCOTUS nominee in the future, investigative journalists, in the case of the 6 I just talked about, all of them women, wait in the wings to do this important work and to bring the results to the public after the fact. The reputation of the court and of the Senate hinge on the Senate taking full responsibility for conducting thorough investigations of sexual misconduct allegations, knowing that if they abdicate this responsibility, journalists will take the lead, the public will see what the Senate failed to do, and the result of that will harm the reputations of the Senate and the court. A quick second point about what the process should involve is bipartisan training for all senators on the realistic dynamics of sexual assault. Senators' questioning of the accusers in both the Thomas and Kavanaugh hearings demonstrated a lack of familiarity with the realistic dynamics of sexual assault. Sexual assault victims often engage in behaviors that are misunderstood and may be viewed as counterintuitive by those who are not well-versed in sexual abuse and sexual misconduct. And if fact finders do not understand the dynamics surrounding sexual assault, they may misinterpret behaviors that are common reactions to sexual assault, making an unwarranted adverse credibility determination against the victim. There's more I can say about that, but I'll skip that and just focus now. I want to turn to my proposal on this innocence standard that I mentioned. When Arizona Senator Jeff Flake issued a press release announcing his support for Brett Kavanaugh, he cited the presumption of innocence that our justice system affords the accused. And in taking this approach, Flake echoed the words of Alan Dixon, a Democrat from Illinois, who voted to support Clarence Thomas back in 1991. And according to Dixon's former speechwriter, Stephen Roderick, Dixon justified his vote for Thomas with the following words, which Roderick helped write: "If Judge Thomas had been credible and Professor Hill had not, the Senate's choice would be clear. But since both were credible, however, and since it is impossible to get to the bottom of the matter, I think we have to fall back on our legal system and its presumption of innocence for those accused." In both of these cases, the senators acknowledged that women had made credible allegations of sexual harassment or assault, but they ultimately decided to support the nominee by resolving any doubt in the nominee's favor. The problem with this rationale, as Roderick pointed out years later, is that the presumption of innocence is a standard that applies to criminal defendants facing penal sanctions if they are not guilty, if they are found guilty. Flake and Dixon applied a standard used in criminal proceedings to a civil context where that standard is inappropriate. Proof of guilt beyond a reasonable doubt is the standard of proof required by our criminal justice system, rightly so when a defendant's liberty and sometimes his or her life is at stake. But the judicial confirmation process is a job interview. It's not a criminal trial. None of the nominee's fundamental rights are at stake. Participation is voluntary, and thorough scrutiny of the nominee is critical to the integrity of the court. And the position of a Supreme Court justice requires individuals who can meet standards of ethical conduct that are more stringent than those that are required of most other people. Such nominees, therefore, should have the burden of demonstrating their innocence beyond a reasonable doubt, what I call the innocence standard. And this is clearly an exacting standard, but it's the only standard that's appropriate for this important and high office. And actually, President Trump actually alluded to an innocence standard in the days leading up to the Kavanaugh vote in late September of 2018, when he stated that there shouldn't be even a little doubt about Kavanaugh's innocence in order for him to move on to confirmation. The court's integrity and reputation require beyond a reasonable doubt certainty that justices have not engaged in sexual misconduct. If there's any doubt on this matter, a nominee should not be seated on the court. In a country of over 1.3 million lawyers and only 9 Supreme Court justices at any given moment, there should never be a shortage of qualified candidates who have never been credibly accused of sexual misconduct. The only question is whether we will make it a priority to hold future nominees to this standard. So I'll end there. I have 1 minute left, but I will move on. We can always talk about things in the Q&A. Thank you.
Thank you so much, Professor Avalos. And now we have Professor Joanne Sweeney, who should be joining us on Zoom.
Hello, everybody. I'm going to share my screen. I just wanted to thank everyone at Baltimore, Sarah, Christine, and Michelle, who were able to switch me to online, to doing it online. Since yesterday, when I realized that I do, in fact, have the flu, not trying to brag, but I apologize in advance if I'm a little slower than usual, and I am timing myself so that I don't go over. So my topic is about the Me Too movement and social media vigilantism. I'm going to be talking about whether Me Too movement, which has been accused of being vigilante justice, whether it really fits that description. What are the and in what ways? What are the drawbacks of being considered a vigilante movement? And which includes a backlash against the accusers, and then finally, what can Me Too do to kind of escape the drawbacks of being a vigilante movement, whether it is or is not, it is at least being perceived by some as vigilante justice. So I don't think I need to spend too much time on what the Me Too movement is. I suspect most people are very well aware of what it is. I just have this little timeline here, just pointing out that the actual Me Too movement was started in 2006 by Tarana Burke on MySpace. And then the resurgence of it in 2017 began after the New York Times published an article about Harvey Weinstein and Ashley Judd's accusations against him. 10 days later, Alyssa Milano used the Me Too hashtag on Twitter. And that's when things started really moving. And that's in that October, November is when a lot of high profile celebrities started being named as people who had been abusive towards women. In January 1st, 2018, that's when the Time's Up movement was created. And then in April 6th, this was the first instance I could find so far of something, a real backlash against Me Too, at least publicly made by a celebrity as Me Too being denounced as women just using this victimhood to gain significance. The word vigilantism hadn't been coined yet. And then we move forward to September 16th in 2018, and this is the Kavanaugh confirmation hearing. And then in 2020, February 24th, 2020, that's when Harvey Weinstein was actually convicted of sexual assault. So these are there's obviously way more, but this is just a brief kind of showing that once it got picked up in 2017, it actually moved very quickly. So the Me Too movement didn't begin with naming people. It began on social media as a conversation between survivors, whether in MySpace or then again on Twitter in 2017. These early posts or tweets just said Me Too or kind of described what had happened to them. And the naming of the perpetrators started happening a little bit later, but these names are what really got picked up by the media. And so my thinking on this is that the media had the mainstream media, public media had a big influence on Me Too in a variety of ways. So the resurgence happened in the wake of this New York Times article, which may have impacted how people thought of the movement, or at least, when it got started up again in 2017 or went viral. And so maybe that's why more names were named early on, is because people were thinking about a specific case. But the media started reporting on Me Too pretty quickly, but the real deluge of it started happening when these names started getting mentioned. And I think that really set the tone of the movement, and what made it go viral and get more popular and go global was that once the media started picking up and people who weren't really active on Twitter, or at least weren't active in, paying attention to these kinds of hashtags, weren't following Alyssa Milano, for example, started learning about this movement and kind of joining in. So it's this cycle of these names being reported, leading to more people posting, leading to more names being given. And the survivors said they felt braver when these to even tell their own stories once these famous and powerful men started being called out and actually suffering consequences, generally, at least in the beginning, not legal consequences, but employment, most likely consequences, getting fired from projects or things like that. But I also want to point out that a lot of traction was gained, I think, in this movement, at least in the mainstream media, because famous people were naming famous people. So politicians, actors, journalists, or the restaurant industry, but like these famous chefs being named. And often it was actors naming directors and things like that. So that made it more attractive, I would say, for the mainstream media. So that's what the Me Too movement did, and that's how the name started going. And then it started being accused of being a vigilante movement, and that made me think about what is vigilantism anyway. And so I did a bit of research on that. There are a lot of not as much, especially in the law review or the law journalism, the law academia, legal academia hasn't really defined vigilantism that well. Social scientists have done more work on this, but pulling together a bunch of sources, I kind of came up with some major categories for what vigilantism is. So the first thing is that it's private citizens, not any government actors or the police. This is, these are private people, and they work together in a group. Their purpose is to protect the group or society in general from what they perceive as some kind of moral or legal transgression. And then there's also an absence of effective governance, or the criminal justice system is being ineffective, requiring the vigilantes to act. And then a part of this, what the movement seeks to do is generally to punish these transgressors, typically outside of the criminal justice system. So in that, using these kind of broad categories, Me Too does have some traits that could be correlated. So for example, the private citizens working together to protect the group. The Me Too movement, the hashtag itself creates this common group based on a single issue, which is the abuse of women, either through harassment or sexual assault or other things. And I'm saying women, I just want to point out, I am saying women kind of as a placeholder. I am fully aware that men are subject of this abuse, and particularly people who are gender nonconforming are certainly targets more than women even. So I'm saying women, but please know that I am aware and that we should all be aware that these acts happen to not just women and not just by men, as there have been plenty of stories about even some proponents of the Me Too movement being accused of committing sexual harassment. So the hashtag, what's happened because of the use of this hashtag and what the purpose of hashtags are, is that this hashtag itself now means something. If I did hashtag Me Too, I'm not talking about, someone says, I like pizza, and then I'd hashtag Me Too. That's not what's happening. It has a specific meaning that alerts a reader and people follow the hashtag that they can start seeing things about this specific topic, which is this sexual assault or harassment or other abuse. So it is created a community, this hashtag itself, and people who are trying to communicate with sympathetic, like-minded people can just use this hashtag to tap into this community. And the part of this movement, a big part of it is this concern of, protecting the victims of these crimes. And so in that sense, it starts to look something like a vigilante movement, at least in this piece. There is definitely a failure of the criminal justice system. I will not belabor this point. It has been stated so beautifully by everyone in this so far that the criminal justice system has failed victims of sexual assault and harassment repeatedly. The statistics bear it out, lack of reporting, and worse, lack of prosecution. And even if you are convicted of rape, you can get 6 months in prison if you're a good swimmer. So that is very much part of this vigilantism definition, and definitely part of the Me Too movement. And then the final piece is punishing transgressors, which has happened, not to everyone and certainly not consistently, but even very powerful men have been punished, and sometimes by the legal system, but more often it's people, like I said, getting fired or being publicly shamed. And because of these vigilante traits, perhaps, and there are other things that can be done as well, other reasons perhaps, particularly if we look at who's being accused, and that it's generally white men. There has been a backlash against Me Too in a variety of different ways, one of which is that it's been accused of going too far, which means that both women and men have famous people as well, and even commentators and scholars have questioned whether Me Too has gone too far, and that it's going beyond the original purpose of sexual assault and even harassment into things that they don't really consider bad enough to get kind of swept up in the movement. The movement has been accused of not being able to differentiate between bad sex and assault. I'm referring specifically to the Aziz Ansari incident. There has been evidence that men are now more reluctant to mentor women or socialize with them in a mentoring capacity, and which has been referred to as the Mike Pence effect. Under Trump and DeVos, there were Title IX rollbacks, perhaps in reaction to Me Too. In fact, I think they specifically said that it was. And then one of the biggest criticisms of Me Too was that it has been accused of punishing men without due process. And this relates to very similarly to the accusations of lack of presumption of innocence in the Senate confirmation hearings, right? That there should be due process, which is questionable considering what's actually happening to them. Again, a lot of this is employment stuff, and so are you, required to have due process for something like that is very questionable. But the accusations are men of being punished for behavior that happened a long time. Even though there's never been a criminal charge, they're still being fired and suffering consequences. And another, I think perhaps the most salient complaint is that they're being punished for anonymous allegations, that the accuser is not coming forward. The backlash has led to a lot of effects. Again, most particularly punishing the accusers. They are being doxxed and harassed. Christine Blase Ford is a prime example. And there have also been defamation lawsuits made against women. There haven't been any successful ones in the United States. There have been a couple settlements, but internationally, there are certainly there have been some cases where women were both civilly and criminally found to have defamed the person they accused, usually resulting in a fine. And just to kind of start rounding out, the main difference I see between Me Too and vigilante movements is that's not why it was started. It was not started to punish anybody. The original purpose was to create a shared community to support, to provide information. Me Too began as something that was victim focused, and just to show the world kind of how widespread the problem is, but it was always focused on women talking to each other. And again, I'm saying women, meaning all groups that have suffered this. So that is something, and Me Too itself doesn't ask for anyone to identify their transgressors. And in fact, Alyssa Milano's original post just said, say Me Too if this has ever happened to you. And I think that's a really important point to remember. And that also to remember that Me Too has actually been a wide variety of ways, and not just in the ways that have been widely publicized, i.e. people getting fired. The Time's Up Legal Defense Fund, which was a spinoff movement from Me Too, has raised over $24 million and connected 3,500 survivors with attorneys. They've actually done a lot of good work. There have been an uptick in EEOC complaints and damages awards by the EEOC. There have been legislative changes, laws passed where you can't have NDRs for sexual harassment settlements or tax write-offs, because that was a thing. And then there have been public perception changes overall, which has led to larger jury awards and judges being less likely to award summary judgment against people arguing a hostile work environment or sexual harassment. So the last piece I'll say is just getting back to these roots, I think, is a really important way for Me Too to kind of escape the clutches of this moniker of vigilante justice and the consequences that attach if it is vigilante justice, and to return to being more survivor focused. And I will argue that I think it's the mainstream media that has made it less of that I don't think it's the movement itself that wants to be punishing people. I think it is more survivor focused. And certainly Tarana Burke, the founder of the movement, is very survivor focused. So focusing more on that and providing information and support to survivors. And then the next step, which a lot of people have argued, is, focusing on more structural changes rather than just pinpointing a few bad actors. Because the whole point of this is how widespread the problem is. And the Time's Up movement has done a lot of this work already, which is focusing on lobbying and education and resources for survivors to go to court. I think that might be it. Yeah, finished under time, 15 seconds. So I'll stop for now. Thank you.
Thank you, Professor Sweeney. Up next, Professor Dalstrom.
Okay. These are hard acts to follow, especially because they both kept time in addition to being excellent presentations. So first, I just want to thank you. A big thanks to the Center for Applied Feminism and to Michelle Gilman and Margaret Johnson. It's just such an honor to be here and presenting alongside the many giants in the field whom I admire and respect. So thank you for that. So my paper is entitled The New Pornography Wars. And I'm going to grab thank you. And it charts out the use and evolution of federal anti-trafficking statutes to apply to certain forms of pornography. And it posits that a, quote, new pornography war is ensuing to reevaluate and redefine the contours of liability for sexually explicit images. And I have first a confession with regard to the theme. It is not my big idea. I'm going to be talking a little bit about the big idea question mark, observing this trend in terms of creative civil litigators using and mobilizing the trafficking framework in order to get gains for certain survivors, and asking the question, what benefits may flow from this frame, and also what challenges or harms may flow from it.
And if we could have the PowerPoint.
You don't have it. That's okay. So as many of you all know, I'll go ahead and keep going, and we can. Oh, you can fix it. Oh, good. Excellent. Oh, or the Zoom has to be, it's here, but we're good. Okay, the big unveiling. Okay. I don't need to tell you all, in the 1970s and 80s, radical feminists like Catherine McKinnon and Andrea Dworkin, amidst great controversy and also feminist backlash, identified connections between pornography and trafficking. In fact, in a 2005 Law Review article, McKinnon noted the potential of trafficking statutes to address forms of pornography, saying laws against sex trafficking, international and domestic, criminal and human rights laws, specifically their concept of commercial sexual exploitation, are more promising for addressing pornography than has been recognized. However, only recently are we seeing efforts by survivors and prosecutors in the US to invoke trafficking statutes in the pornography context. So this article is an effort to interpret those recent efforts, to consider their implications, both for trafficking law and the pornography industry more generally. And it draws from my earlier work looking at the elastic meanings of trafficking. Others have also examined this around how trafficking law has been expanded to target new actors and new conduct, including hotels, websites. You'll have seen this as well as interpersonal violence, and laying out some benefits and also challenges associated with those creative litigation efforts. So you might ask, how did this project come about? So I became interested in this issue given the emerging public narrative, of which I'm sure you're aware, about Pornhub, an online platform now infamous for images of rape, child pornography, or child sexual abuse imagery, and sex trafficking. So these headlines likely look familiar to many of you. You may know that on December 4th, 2020, Nick Kristof of the New York Times wrote an op-ed entitled Children of Pornhub. And in that piece, he detailed stories of children who he said were raped and sexually abused and who had videos uploaded to Pornhub. And he acknowledged that the majority of 6.8 million videos posted on the site, quote, probably involve consenting adults, but accused the site of being, quote, infested with rape videos, and detailed the plan by MindGeek, the owner of Pornhub, the business plan, which he said monetized those harms. This op-ed, as you may have heard, gave rise to a public outcry. This is one organization, an anti-pornography organization, that proclaimed, quote, "This is a reckoning," promising to bring both public and corporate pressure against MindGeek and Pornhub. And it quickly gained more than 2.2 million signatures on a petition to end Pornhub and support from 300 organizations. And meanwhile, companies began to cut ties from Pornhub. Visa, MasterCard, Discover, Roku, Comcast. Public pressure then spurred legislative interest, sparking an investigation before the Canadian Ethics Committee, where MindGeek is based, and 3 bills were quickly introduced in the US Congress to address non-consensual images. And as pressure grew, MindGeek also took action. They purged millions of videos from its site, removed the download button from their site, which also had drawn criticism for allowing users to both download and re-upload images, and strengthened moderation efforts. So overall, looking at these stories that were coming out, it seemed to be a story about public and corporate pressure. But as you look further, what I found, and many have looked to, is an important story that was emerging about liability and the role of trafficking statutes. For example, the Kristof op-ed. In that op-ed, survivors, including a young woman featured in the op-ed, filed new landmark cases against MindGeek under federal anti-trafficking statutes. And they argued that MindGeek's failure to remove not only the images of sex trafficking, but also the images of child pornography, non-consensual pornography, a wider array of harms from the statute violated anti-trafficking laws. And they also targeted third parties like Visa, Colbeck Capital, a financial firm, arguing that they bore expansive third-party liability for knowingly profiting from that trafficking conduct. So I became interested in these cases. What work was the trafficking as a concept doing? How does this compare to the earlier sort of pornography wars of the 1970s and 80s, where feminist activists tried and were unsuccessful in carving out a very broad civil remedy for pornography more generally that subjugated women? And how far will liability stretch? As many of you know, let me catch up here. As many of you know, in the 1970s and 80s, McKinnon and Dworkin, feminist activists, sought to employ this, quote, civil rights approach aimed at pornography writ large. And amidst great controversy and pushback, they promoted local ordinances that is to establish a civil remedy, believing that unlike the then existing obscenity frames, the civil action brought attention to those harms, centered certain women's voices, and also promoted legal accountability. But those efforts were largely unsuccessful, opposed by other feminists, and also, struck down in Easterbrook and Hudnut, who found the measures to be content-based restrictions on speech and an impermissible form of, quote, thought control. Since then, much has happened, as we've talked about today. Me Too, the civil rights movement, obviously much has evolved in the online pornography space as well. And yet new trafficking frames, like these earlier feminist efforts, in some ways, in fact, very similar, seek to carve out a civil remedy for, again, some survivors. They seek to try to give new voice to survivors in federal court, but they're also distinct, right? So they're distinct from these earlier efforts in their framing. So whereas McKinnon and Dworkin aim to show how pornography itself was a form of violence against women, these new efforts seek to distinguish most consensual pornography from images of rape or sexual violence, and to get at the role of corporate entities and third parties who profit from them. And I'm just going to quickly read or play a very short video from the lawyer who's representing some of these survivors, so you can get a sense of the frame. If I can do this. Let's see.
This is about rape, not porn. It's about trafficking, not consensual adult performance or entertainment. This is not about policing consensual adult activity. It's not about religion. I think even in these days, everybody can agree that no industry should be commercializing and monetizing rape, child abuse, and traffic content. And I think we all expect that any legitimate business or industry wouldn't do so and would do whatever it could to make sure that type of content doesn't pollute its product.
Okay, so as you can see, the framing is quite different than early feminist efforts or early radical feminist efforts. So what contribution does this paper try to make? First, it tries to show how sex trafficking statutes are being mobilized, why they're attractive to litigators, and then it engages around some of the harms of this move and of the move to invoke trafficking rather than other, perhaps more tailored solutions. So as many of you in this audience know, Congress passed federal trafficking law in 2000 and created a sex trafficking crime where there was a requirement of intent, force, fraud, or coercion, and the inducement of a commercial sex act, which was pretty broadly defined, unless there's a minor. Then in 2003 and 2008, through subsequent reauthorizations, it created a federal right of action, and essentially against both direct perpetrators and third parties. And that knowledge requirement for third parties was fairly broad. So the defendant, if the defendant knew or should have known that they benefited from a venture with a perpetrator of trafficking, they may be held civilly liable under that standard. And since then, what we have seen is an explosion of civil litigation against perpetrators and third parties, in part due to this lower knowledge standard. So just in the last 2 years, there were 406 federal civil trafficking statutes. So given that background, the article observes a few trends, still somewhat nascent, around the types of cases that we're seeing. Sorry, I'll just go over here. Primarily, first, in terms of seeing framing pornography involving force, fraud, or coercion as trafficking. Second, framing child pornography or CSAM as trafficking. And then the third and much less resolved issue is framing all non-consensual pornography as trafficking. Okay, given my time. So civil litigators have started to bring new civil and criminal cases asserting that pornography involving force, fraud, and coercion gives rise to direct and third party liability under the federal trafficking statute. And we've seen that primarily in a case involving Girls Do Porn, where federal criminal prosecutors have brought thus far successful in the sense of guilty pleas, which we could talk about whether that's success, but there are cases that have resulted in 3 guilty pleas in California against those who allegedly engage in coercion in the pornography setting. Following those guilty pleas, survivors brought federal civil claims in federal court, arguing that MindGeek and Pornhub, by hosting those images, should be held civilly liable. We've also seen, in the context of child pornography, and I'm just going to briefly go through this so we can get to the benefits and negatives of this, that commercializing the sex act, essentially monetizing by uploading, is sufficient to be a commercial sex act under the trafficking statute. And because force, fraud, and coercion is not required with children, that in itself is sex trafficking. And we've seen a couple of district courts already at the motion to dismiss stage allowing cases to move forward. And then finally, this question of non-consensual pornography as trafficking. So there's a case involving Serena Fleets, which is also the individual in the Christoph article, where they're arguing in that case in part that non-consensual pornography, so a sex act that was uploaded without consent, could amount to trafficking. So the piece just outlines a number of benefits for the survivors who are filing in this move. One, it does create potentially successful new federal remedies. It broadens exceptions to the Communications Decency Act. So I know we don't have enough time to get into FOSTA SESTA, but essentially there was an exception created for trafficking conduct. So by expansively interpreting trafficking conduct, it allows for more individuals to get into court against online platforms. It also expands third-party liability pretty substantially. So we're not just talking about online platforms, we're talking about payment processing companies, we're talking about financial firms. And the question is whether it also expands what might be unprotected speech, which I'm happy to get into in questions. And it's a rhetorical tool that might be effective for advocates and victims, right? And framing out in filing these claims, they're talking about trafficking where there might be uniform condemnation, whereas if they were talking about non-consensual pornography or some of these other, in using other rhetorical frames, it might be more challenging. So the piece also articulates potential costs of this move. In the FOSTA SESTA conversation, since the FOSTA SESTA has been passed, there's been great concern about pushing harms underground, about ensuring by regulating online platforms more, pushing those harms onto other sites and harming kind of the most marginalized, whether it's those working in commercial sex and other settings. Trafficking also may be a sword used by corporations. So we've started to see this with Apple going at sex trafficking and child pornography, but using that as a mechanism potentially to surveil individuals in ways that may have very profound civil liberties implications. And then finally, improperly calibrated third-party liability and what that might mean for sexual expression more generally. So, and we're already starting to see that as we see broadening third-party liability, whether that's with Visa or other similarly situated companies, we're going to see people pulling back from the pornography industry more generally with broad impacts around expression that would be otherwise protected. So with that, and given time, I think what I'll do is end here and welcome questions as well. Thank you.
And last but not least, we have Professor Emily Stiltzenberg.
Okay, so first of all, thank you so much to the Center for Applied Feminism. I am thrilled to be here. And just to let you know, we're doing a little bit of a switch. So the overarching theme of this panel is consent. And so the first three panelists, we're looking at consent as it may relate to sexual activity. I'm talking about consent to financial obligations. So there's a bit of a switch here. So the goal of my project is to expose and critique the role that consent plays in justifying who bears the burdens of social reproduction in the United States. So in our society, responsibility for social reproduction, which I'll define loosely as raising and socializing the next generation, as well as caring for current generations, that responsibility here tends to fall heavily on families. Family law scholars call this policy choice privatizing dependency, which means we're making individual family units responsible for meeting their members' needs. We could contrast this with a more collective approach to social reproduction, that is, spreading its burdens more widely by providing various forms of public support for caregiving. So the United States is known for its entrenched skepticism toward the welfare state, toward public support for social reproduction. And despite the experience of the past 2 years, this skepticism appears to continue unabated today. So why do efforts to expand public support for families fare so poorly in the United States? Scholars have adduced many practical reasons, and this paper adds another ideological one. I argue that the US's harsh approach to social reproduction can be traced in part to family law's lack of imagination in dealing with the problem of political obligation. In particular, to family law's conviction that family support obligations can be incurred only on the basis of consent. That works to limit collective financial responsibility for families. So note, when I say family obligations, I'm specifically referring to financial obligations, so requirements to share property or provide financial support. And I'll use family law as a shorthand for family obligations. Okay, so returning to the problem of political obligation. Like all bodies of law in a liberal state, family law has to explain how its exercise of coercive state power is consistent with citizens' freedom and equality. The standard liberal answer to this question is consent. So consent transforms the exercise of state authority from external compulsion into the mere extension of an individual's internal will. What Heidi Hurd has called the moral magic of consent makes consent an especially strong basis for justifying legal obligation. I argue that consent is the only basis used to justify family obligations, to the detriment of both family law and the families it's meant to protect. So first, I'll defend my descriptive claim about the primacy of consent in family law, and then I'll focus on that primacy's negative consequences. Consent-based obligation has a long history in family law. So under canon law, which governed entry into marriage, the only element necessary to contract a valid marriage was consent of both parties. And then once the parties had consented to marriage, the common law of coverture caused a range of obligations to attach. And those marital obligations worked to subordinate wives to their husbands. Consent-based reasoning also justified laws that subjected children to their fathers and excluded enslaved persons from legal family relations. So children's duties used to be theorized in terms of hypothetical consent, and the law denied enslaved persons contractual capacity, which meant that they couldn't marry. So under these historical regimes, consent was used to legitimate patriarchal and hierarchical structures of family obligation. This is the first suggestion that we should be a little bit skeptical about consent as a justificatory tool. Despite modern family law's turn toward equality and autonomy, the concept of consent continues to justify family obligations today. So I argue that this is true for spousal obligations, cohabitants obligations, and parental obligations. So spouses' consent to marry continues to justify the states imposing marital obligations. Okay. We see this in the divorce distribution regime when marriages end. unless spouses execute a premarital or a marital agreement. So in that case, consent to that contract will justify the states enforcing the parties' agreed to obligations. When intimate partners cohabit but don't marry, courts cite their failure to consent to marriage as a reason not to impose family-based property sharing. But at the same time, the law is often undermining cohabitants' ability to consent to contractual obligations because states will impose heightened level of formalities that aren't required between non-intimates. A parent's financial duty to support a child is also grounded in consent. So for example, the marital presumption and voluntary affidavits of paternity are both based on consent. So in the first case, consent to marriage. In the second case, consent to sign the vow. Consent gets stretched the farthest to legitimate obligations in the case of non-marital fathers' duties to support biological children. So in this case, consent to sex is read to be consent to the birth of the child, which then becomes consent to financially support that child. Juxtaposing all of these concepts shows that consent is highly malleable. So in some contexts, the law's reliance on consent seems sensible. Okay, the construct is doing a good job of capturing the individual and the social interests at stake. And so in those cases, deferring to individuals consented to arrangements is going to both further their autonomy and increase social welfare. But as I've shown, this is by no means true in all contexts. And as a result, family law's failure to treat skepticism with consent with skepticism creates three problems. Okay, so I focus here on three related problems. So the first is doctrinal, and then two more are normative. So the doctrinal problem is that consent means different things in different places. And that makes family law doctrine look incoherent. The result is that we are decreasing the legitimacy that relying on consent is supposed to engender. The second problem, the first normative problem, is that fetishizing consent precludes family law from deeper discussions of other normative commitments that are still there, working quietly underneath the surface of the consent discourse. And then finally, consent traces the source of an obligation to an individual's will, which means it's difficult to consider society's interest and role in family relationships. So from that, we end up with two distinctive problems of distributive justice. So first, without recourse to other normative considerations, the law's reliance on consent alone ends up blessing unjust distributions of property between family members. So for example, courts will enforce marital contracts that may be quite one-sided. And for example, courts will refuse to distribute property between cohabitants, even when those cohabitants had significant economic entanglement. Second problem of distributive justice is that relying on consent to justify obligations makes family members' claims of distributive justice against society totally unintelligible. The logic of consent entrenches the idea that individuals' needs have to be met by those closest to them. Social reproduction then must be a matter of private responsibility. Because how could we task non-family members with family support obligations to which they haven't consented? Thus, the US's failure to provide adequately for the needs of children and their caregivers. I argue that to begin to tackle these problems, family law needs to incorporate additional bases beyond consent for justifying family obligations. So the first step in this argument is to pin down exactly how consent is operating in family law and to identify where family law is asking it to do too much. So to that end, I develop a taxonomy of how family law uses consent to justify obligation. I start with three general questions of political obligation. So first, what's the obligation's source? So what principle or principles potentially justify the exercise of state power against an individual? Second, what causes an obligation to attach? And third, what's the content or the scope of the obligation? So what's the individual required to do or not do? So the first question is the fundamental question, and it has a lot of possible answers. Indeed, different doctrinal areas rely on different principles to justify their regulation. But as I've shown, family law's sole answer is consent. So reflecting that answer, we can paraphrase the three questions to reveal three different dimensions of consent in family law. So we have first the realm of consent. So which obligations, what percent of obligations can be justified by consent? Second, the manifestations of consent. So what does an individual have to do for the law to find consent? And third, the consequences of consent. So what follows from that appropriate manifestation? So because family law limits itself to consent alone as a basis of legitimation, the realm of consent, that first dimension, is fixed at 100%. Okay, consent becomes conterminous with the boundaries of family law regulation. And as a result, family law spends most of its time fighting about dimension 2. What are the manifestations of consent? So when courts and scholars can't find appropriate manifestations, they say a proposed obligation doesn't exist. So for example, cohabitants don't have to share because they didn't get married, because they didn't sign a contract. They're outside the realm of consent. They're outside the realm of family law. But this determination is being driven by the consequences that would follow from a finding of consent. Okay, so the third dimension. And cohabitants are out of the realm of family law because the consequences they ask for are so big. They're usually looking for full marital redistribution. Now consider child support obligations. Okay, so here it seems commonsensical that we would have certain obligations. And for that reason, family law attenuates consent to allow for manifestations. Okay, so here, if you act in a way that could foreseeably cause a child to be born, then family law will attach as a consequence the duty to provide for that child. Right? Even when we have a set of cases, male victims of statutory rape, where there's arguably no consent to sex, you still have a parental support duty. Appealing to consent alone means that family law has to define consent's manifestations and consequences differently in different contexts. That makes the law look inconsistent. Sometimes we require express consent. Other times, consent can be implied or even constructed. Focusing exclusively on consent also makes it difficult to talk about other values that might be motivating these different consent requirements. For example, in the child support context, the use of family obligations to privatize responsibility for dependent children. Or in property disputes between adult intimates, the conflicting principles of autonomy and equity. And again, consent's individualistic rhetoric makes it hard to discuss obligations that originate from the reality of living within a community, whether the community is a family or a polity or a family embedded within a polity. To begin to relieve these pressures, I argue that family law needs to incorporate additional bases beyond consent for justifying family obligations. These bases might include avoiding or remedying harm, protecting those in relationships of trust, or fairly spreading the costs of caring for the vulnerable. As a legal matter, these obligations could be instantiated through tort-like duties, fiduciary-like duties, and redistributive taxation, reflecting principles of distributive justice. So these additional bases could invoke certain doctrinal reforms within family law, okay? But they also have impact outside family law. If we took a pluralistic approach to family obligations, that might lead us to break down doctrinal boundaries between family law and fields like welfare law and employment law, because we need to rethink all of the structures that society uses to make our citizens' basic material needs. A pluralist approach to family obligations would also allow us to acknowledge that families help us to realize many important social goods. And once we articulate society's interest in well-functioning families, we have better grounds to argue for a corresponding social obligation to help all families flourish. And if we understand the obligation to support family members as a duty of all citizens, not just particular intimates, then family law becomes much broader and more widespread than we currently imagine it to be.
Thank you, Professor Stolzenberg. Thank you all so much for those interesting ideas. It's amazing to hear you give voice to these areas where there hasn't been voice or process in the past. And I already see hands up in the audience, so we'll begin with questions.
My question is for Professor Dalstrom, and I think you anticipated it because I think it's at the end of your last slide. Yes. And it's in conversation with your previous work, which is, if everything is trafficking, is nothing trafficking?
Do you know the answer to this, Lee? I was hoping you knew the answer. I actually did teaching a gender violence in the law class in which I assigned your portion of your book, one of them, and asked the students this. And I think this is the question. So if we're looking, so one of the things that brings some of these our pieces today together is if we're looking to other frames in order to reform or sort of fix barriers within the law, is that going to effectively act as a solution? And so I argue in my other work that I am skeptical that it is going to provide the solution that we seek. So I charted out, for example, trafficking is also expanding in the sexual assault DV setting, and I think it's going to give rise to a disproportionate sort of criminal harms and some other consequences, and that we really do need, if you believe in reform, which I know is a big if, but if you do, then I think they need to be happening within these frameworks, not looking to invoke trafficking, for example, or other frames which perhaps don't allow for a more nuanced discussion of some of the harms. Thank you for that. That was also an effort to allow me to have one more minute to talk. So thank you.
Thank you. So my question is, I guess, for Professor Avalos and Professor Sweeney, if she is still there. So I am wondering, particularly thinking about the popular rhetoric about sexual assault in particular, there's this conflation of criminal standards with civil standards, talking about, reasonable doubt and due process, and using that criminal standard in a non-criminal context. And there's a way in which that equates criminal consequences with civil consequences that can make those civil consequences seem more serious. Is there any concern or danger of making criminal consequences, actual criminal consequences, seem less serious with this conflation in a way that harms the movement against mass incarceration, which we know disproportionately affects communities of color and in particular survivors?
Oof, that's really complicated.
Yeah, go ahead. Go ahead. You take that one.
So I have a lot of thoughts on this. I honestly think the people that invoke these arguments aren't as thoughtful as you're giving them credit for. Cynically, I think that people are invoking these concepts because they don't like people being punished for things that they don't think is that big of a deal. I think they don't like people being punished for things that if they really thought really hard about, they would probably find something in their history that was problematic. And so I don't think, and that's one side of it. The other side is that, the criminal justice system has biases against, against women being believed. That's one bias, but it also clearly has biases against people of color. And the intersectionality, and those are, some of the topics that were brought up earlier today is lethal in a lot of respects and truly toxic. Because if you are a Black girl accusing a white man of raping you, you're less likely to be listened. But if you're a white woman accusing a Black man falsely accusing, you're more likely to be listened. And that goes to rape myths and all kinds of stuff. So it's, as I said, hugely complicated. Do I think that I don't see the danger that you articulated specifically, but I do think that what you're pointing to is, I think a lot of people are just uneducated about what these standards are for, and they just see something that they don't like and they find a legal concept and they just apply it without thinking it through. Could it have the impact that you're suggesting? I don't know, because as I said, I don't think that it's as thoughtful as you're giving them credit for. But there's always, if people, cis het white men, apologies if there's anyone in the audience that fits that description, I cannot see you. But if that's the, they're concerned, I would say cynically, mostly about themselves. And so could it be used that way to punish people that they think should be punished? Therefore, yes. I don't see that in the literature and I don't see that in the news as much, but is that a danger? I suppose so. Yeah. God, did that answer the question at all?
Yeah.
Okay, good.
I agree with all of that. I'd say go on to the next question.
She says ditto. My question is also for Professor Dalstrom. I know there were a couple of other costs that you didn't necessarily get to touch on, and I apologize if this was one of them and I just couldn't see it. I was furiously scrawling. I agree that the harms go underground. I agree that this can chill sexual expression, but I think one of the other challenges as an long-suffering anti-trafficking activist is that I believe that the majority of anti-trafficking attempts to curb trafficking actually enable it. Yes. So in this capacity, there are visas pulling out of OnlyFans and Pornhub and all of this. And it actually kind of links with the presentation that we had at lunch, where when people are not in control of their economic independence, exploitation can follow. And whether you want there to be or not, people are engaging in sexual labor and they will continue to do so. And in fact, that is one of the most accessible forms of labor to the most marginalized individuals. And the more that we, quote unquote, chill their access to that, we push them underground as well. And so I think that's my primary challenge with this. And I'd just love to hear your thoughts, is that when we limit people's rights, we enable trafficking, whether that's in the immigration context or the labor context. And I think here in the civil context, we're talking about enabling trafficking, and it's time for us to start calling it what it is. And sorry, I'm just annoyed.
So this is great. Can I use this quote? And I'm going to incorporate this. So Jessica is an expert in her own right. So I take it as an honor that she asked the question. I will say absolutely. I was just hearing about this great report Posting into the Void, which you're probably aware of as well, talking about those who are working in the commercial sex industry and the impact of FOSTA SESTA and the impact of the policing now of online platforms and shadow banning and people not being able to post in that space and having to change performance in the spaces where they are able to access. And absolutely that enables greater potential trafficking or other forms of exploitation too.
A question for Emily. I'm wondering if you carry out your thesis to its ultimate conclusion, what you're really talking about is getting rid of family itself. Forget about legal regulation and that consent, but what is family? Do we need it as a construct? And what is it for? Because if you think about family as sort of this privatized sovereign that the state has decided they should outsource the caretaking to, so the state doesn't need to, are you now saying that, no, it should not be outsourced, it shouldn't be privatized, it shouldn't be its own little sovereign, and thereby it really maybe doesn't need to exist as a structure anymore?
So I think someone could take it that far, but I'm not the person who takes it that far. So I'm looking for, and I'm sorry to be quoting this, but I'm looking for more of a private-public partnership because I think families do really important things that are not just resource distribution and resource provision, right? And I think families are actually hindered in their ability to do those important things, right? The more hands-on caregiving, the emotional labor, like the stability provision, the identity formation, because in our current society, they're so busy running the market rat race, right? And so if we had more public provision of material resources, whether that is funding, right, directly to families, whether it's funding to institutions that support families, there could be a number of ways to do this, and we probably need a bunch of different ways. Then families could concentrate better on the things that only families can do. Right? I think part of the problem is we don't have sort of the right structure in our polity for what a family is supposed to do, right? Maybe even internally, but also how family is supposed to function within the society. So I think there are a lot of structural problems that we need to resolve, right? And this project is just sort of opening the door to say, how do we restructure all of these different layers? How should they be working together?
I could just add something to that. We don't see, when we look at societies that have done more to publicize care, the responsibility of caregiving, we don't see families disappearing. I have relatives in Cuba who have much more state support. I spent time in law school living in Denmark, and these are societies that have families that across Western Europe. Families are still there, so they haven't gone away. So I don't think they're at risk of disappearing.
We have one more hand in the audience. We have time for one more quick question.
Thank you so much. I was trying to connect Professor Sweeney's paper with Professor Avalos. So maybe for Professor Avalos. So your talk is focused, or your paper is focused on Supreme Court nominees, because you say they have to have a higher ethical standard, right? So my first question would be, would this just be for Supreme Court nominees, or how do we extend it? Is it all federal judges? Is it all judges?
Right.
What about CEOs of companies? So it could get really broad. And the second question was I'm a little bit concerned about this having to prove your innocence, because what does this mean? If you have a credible person coming forward and accusing you of something, is that enough?
Yeah.
And you're disqualified. I understand it's not criminal, but losing your job can have very harsh, consequences.
Right.
So I was trying to tie it in with Professor Sweeney, who's concerned with the Metoo movement being considered or perceived as a vigilante movement. So it seems like if we were to really take it that far, it would be hard to say it's not. This is also part of Metoo. And it is really going away from the victim focused. It's focused on the abuser. So if you could kind of talk about that, because I have a lot of questions on it, but I also have a concern that if we require people to prove their innocence, is that really where we're heading to? I'm really concerned with that. So maybe you can just talk about that.
Yeah. Thanks. I appreciate that question, and I'll be interested to hear what Professor Sweeney has to say as well. I'm restricting the focus of my paper just to Supreme Court nominees because I think that that's a much smaller universe. And so when I make the argument, I am truly saying in relation to these 9 people in this country, I think that's the standard we should use. I think when we start expanding to all federal judges or some, or other categories of people, when we expand the universe so exponentially, I think maybe we have different questions that we need to ask. So I'm really, for me personally, at this point, I'm only talking about those 9 individuals. And honestly, I understand your concern about what does that mean to prove your innocence. And I'm thinking about this in a very on the ground way in relation to the experience we've had. We've only had 2 instances in the history of this country where accusers have come forward to accuse a nominee of sexual misconduct. And I think we have to take the scenario as it unfolds and ask, is there something that people generally find credible about these particular accusers? And I think that there are a lot of people that found both Anita Hill and Brett Kavanaugh's accusers very credible, and that has left a lingering doubt. Another factor I get into in my paper is that false allegations are very rare. That doesn't mean that somebody could come out of the woodwork and accuse somebody, but you have to have a lot of details. I personally can't go accuse Brett Kavanaugh of sexual assault when I never knew him. I didn't go to high school with him. There are all kinds of details in his background that would not align with mine, such that any accusation that like I specifically would make would not be credible. So I think that we have to allow this to unfold and see, what do accusers look like and what do their accusations look like and how do we address them? Certainly, there are people who have, believe that, all kinds of folks are going to come out of the woodwork and make accusations. I think that what we've seen, and the authors of the books that I mentioned also saw this, it can be extremely difficult for not just for people who are actually assaulted, but also for witnesses and others with information to come forward because they don't want to damage their careers and so forth. So I think that we need to take accusers seriously, but also vet allegations and see where it leads us. I think it's much harder to come up with a credible false allegation than people might think that it is.
I agree with everything you're saying. And I didn't mean to make it seem in my presentation like I didn't want all those men to get fired, because I very much did. And the thing I would say about when you're nominated to be on the Supreme Court, you're nicer than I am, because I would say, yes, all federal judges, it's a lifetime tenure. Let's have stricter standards than Billy Bush got fired from Access Hollywood for just laughing at the joke. But my point the point for, especially for Kavanaugh, if he had not been confirmed to the Supreme Court, what terrible consequence would have befallen him is that he would have just continued to be a DC Circuit judge, which is, I know, horrible. But I don't feel bad. I mean, I'm being very flippant. Apologies for that. But my thinking is that these aren't people that are, if you're trying to be confirmed to a Supreme Court judge or any federal judge position, you are not about to get fired. It's not even as bad as, what has happened to Matt Lauer and people like that, because you have a job probably, and you're not going to get fired. You just don't get to get this better job. So I don't have a problem with having higher standards before we confirm somebody to a lifetime appointment. And the other thing I will point out is that the 2 people that we mentioned, Anita Hill and Christine Blasey Ford, did not want to come forward. Anita Hill, if I recall correctly, was subpoenaed. She did not volunteer. And I don't think that, I know there's this fear that, women are just going to lie in order to, I don't know what, that's one thing people accused, I think Christine Blasey Ford, was that she just wanted to get her 15 minutes. She did not. She was terrified, and rightly so. She feared every consequence that came her way. The fact that she had to hide, she had to leave her home. These are not, I don't think it's, the publicity for the people, for the women accusing these men, particularly in our current society, is not positive. It is not something that they are looking for. So I don't see that much. That is a big danger of these floodgates of women coming forward, purely because we changed the burden of proof on this. And if the standard is, if there is a credible accusation, and I like the idea of using a credible one, so there should be some investigation to start. But if then the nominee has to prove innocence, then maybe we'll actually get a better investigation, and the FBI will actually do its job because they're invested in having that person not be guilty. And then maybe we'll actually get to the truth more.
Thank you so much for that answer, Professor Sweeney.
Oh yeah, I'll be quiet.
We are quite over time, but thank you so much to all of the presenters. There's amazing. Thank you. I'm going to take a short break before the next presentation. That starts at 3:15.